Hey, everybody. Welcome to Thursday night. John Skiba here from the Consumer Warrior YouTube channel. And like we try to do each and every Thursday evening, we do this live stream where we do Q&A about debt-related topics, whether it's bankruptcy, debt collection, lawsuits, wage garnishment, or all those other horrible things out there. Each and every week, we do this on the channel to be able to try to give you some tips and some strategies and maybe some resources on how to deal with pretty serious debt problems. As I do each and every week, I have to give my disclaimer because that's what lawyers do. We give disclaimers. I am a licensed attorney in the state of Arizona. If you have a problem and you're in Arizona, I can help you out. I'm not licensed anywhere else. So you should just take this for what it is. This is just people talking on YouTube. If you need actual legal advice about your specific situation, highly recommend you contact an attorney in your state. Again, if you're in Arizona, I offer free consults. I'll put my notes. I actually put it in the chat already. I'd be happy to see how we can help you out. So the way that this works is if you are on, whether you're on, you have to be on YouTube actually. And you can put your question there in the chat section. I'll put it up here on the screen and we will talk about it. Now, what I like to always do is before the live stream each week is kind of go through some of the comments from the previous week on the various videos that we're putting up and answer some questions that I see come up pretty common in my law practice. This first one is a good one. And this person was criticizing me on my own YouTube channel. Their quote said that this was a topic about default judgments and this topic of whether you can go to jail for not paying your debts. This person said in the comments, "You can't be incarcerated for not paying a debt. This lawyer doesn't know what he's saying." First of all, how dare you to say, I don't know what I'm saying. I don't know everything, but I do know this. I know that in general, you're not going to go to jail for not paying your debts. Debtors' prisons, they were abolished in the United States in the 1800s, and you're not going to go to jail for not paying a debt. Now, there are certain debts where there's an exception to that. If you don't pay your taxes, it's possible that you could go to jail for that, but that's even fairly remote. What I talked about in that particular video is the situation where you can go to jail. It's not actually for not paying your debt. It's more because you're not adhering to a specific court order. So here's how sometimes these debt collection lawsuits will play out. They file the lawsuit, they get their judgment against you. And then once they get their judgment, they can do what's called post-judgment discovery, where they want to get information about where you work, where you bank, all that kind of stuff, so they can start garnishing your wages and making life difficult. Now, you do have to comply with that. And sometimes they'll set even what's called a judgment debtor's exam. This is essentially a deposition where you have to appear in court or at the attorney's office, and they can talk to you under oath to get all this information on how they're going to satisfy the judgment. Now, if you ignore that subpoena or that order from the court, there is a possibility, and in Arizona, it's a real possibility, that the judge will issue a civil arrest warrant. What that is they're saying, hey, you essentially are in contempt. You violated the court order. You didn't show up when you were supposed to show up. And so they issue this civil arrest warrant. Now, this doesn't mean that the police are going to come and kick down your door and pull you out of bed and drag you into jail. But what it does mean, in the state of Arizona at least, is that if you get pulled over for speeding or rolling through a stop sign, something like that, and they see that, they will absolutely take you into custody. And then you're going to have to deal with those, then you're in jail, and then you're going to have to get out of jail to be able to go to do this judgment debtor's exam. So that's where I see people who get themselves in serious trouble. But in general, no. If you can't pay your credit card, you're not going to go to jail. It's always a civil matter. Not going to cause you too much grief. All right, let's talk about the second question. This one was also from the comments. It says, is it true a Chapter 7 bankruptcy can stay on your credit report up to 10 years from the date the bankruptcy case was filed? Yes, it's absolutely true. So in the public records section of your credit report, the bankruptcy will be reported there for 10 years. It'll stay on your credit report. Now, a different question is how long will it actually impact your credit score? It varies because there's a lot of different variables that goes into everybody's credit score, but generally you're looking at somewhere between 18 months up to 3 years as far as really negative impact. Some people see a dramatic increase even within the first year in their score, and that's because it zeroes out all your debts and it's not showing that there's any collection accounts or derogatory information on there. So what I see, like if you file Chapter 7, and let's say you want to get a mortgage loan, generally you're looking at about 2 years. That's the VA. That's a FHA. That you can get those loans with normal interest rates. Other lenders might be 3 years. Car loans and credit cards are available almost immediately for good or for bad. You're just going to get better interest rates the further you get away from that filing date. So hopefully that helps you out there. All right, let's jump into any questions that anybody else has here. First, we're going to thank Al, $5. Thank you. Back in Tucson, still have not been served yet. Can I go to the courthouse and get a copy of the complaint? If so, is that considered being served? So this is a good question because I see this quite a bit where you're waiting for the process server. You knew that they came by and you didn't get served. And so you want to see what's going on. You going to the courthouse and getting a copy of the complaint, surprisingly, that's not service. The opposing side has to serve you with a process server, or they have to provide you with a document called an acceptance of service that then you will submit to the court, and then that would count. But you going to get a copy, those are public records in the courthouse. You can just go get a copy, ask to see it, and that does not count as service. So, Muriel, how are you doing? It's good to see you again tonight. All right, let's go with Jack's question here. I have a pretrial conference tomorrow. When I received the complaint, I never saw this account in my life. What do I do within the pretrial conference? Okay, so I'm assuming this is an Arizona case. Jack, you can correct me if I am wrong. But the pretrial conference, particularly in the justice court system, which is where they usually have them, it's really this really anticlimactic event because a lot of them are done over the phone now, post-COVID, and often it's just between the two parties. Or if they are having it in person, you're going to go there. You may meet in front of the judge. You may not. If you go in front of the judge is going to say this: hey, why don't you guys go out into the hall and see if you can work out some kind of resolution, some type of settlement. If you can't, come back in here and I'll give you a trial date that'll probably be like 4 or 5 months down the road. That's really the extent of it. They may talk about initial disclosures. There's something called a disclosure statement that needs to be exchanged. Basically where you're listing any witnesses, defenses, documents. The plaintiff's got to provide you a copy of their disclosure statement as well. But generally, it's a pretty short thing. It's not a very big deal at all. Truly nothing to lose sleep over. The only thing that's super important is you need to show up. If you don't show up, often the justice courts in Arizona will enter judgment against you immediately. I don't think it's right. I don't think it's fair. I don't think it complies with the law, but that's what they do. They'll enter a judgment against you if you don't show up. So make sure you're there. Be there a little bit early. You want to be on time because sometimes the judges their calendars are going quick, particularly in the justice courts, and they'll just keep moving it through. It is possible as well that you won't even see the judge. They'll have you meet with the opposing counsel in a conference room. Again, there's usually discussions about settlement. And if a settlement is reached, great. Often you can go put it in on the record and be done with it. Or if a settlement is not reached, then you're in a situation where they'll just go ahead and set a trial date and set some of those dates out for you. So again, nothing that I would lose too much sleep over, but definitely make sure that you're there on time. All right, Adriana, thank you for your contribution here. Let's talk about your question. Judge ruled in May for arbitration. However, the debt collector has not provided a date for arbitration with JAMS. What should I do? A lot of this will depend on, so if the judge actually dismissed your case and compelled private arbitration, or if the judge just stayed the case and said to go to arbitration. I tell you, so if they just stay the case, which is what a lot of judges do, they'll say, okay, we'll stop what we're doing here for 90 days. You guys go do arbitration. And then, if you decide not to, whatever, come on back. What I would do particularly if the judge gave you a specific deadline when arbitration needed to happen by, if the creditor has not initiated private arbitration, I may file a renewed motion to dismiss and say, hey, look, judge, you told them to go pursue arbitration. They didn't do it. This case should be dismissed. Now, the creditor, here's what the creditor is going to say. They're going to say, hey, we didn't ask to go to arbitration. It needs to be the defendant that needs to go to initiate that. That doesn't make sense. And I've talked about this before on the channel, because if you look at the terms and conditions of the agreement, it basically says the party who has a claim against the other, they're the ones who are to initiate the arbitration or the court process. in most of these debt collection cases, you don't have a claim against the creditor. They have a claim against you. So if the court's compelling arbitration, they should be the ones who initiate it. So I think that's kind of a bogus argument. And you just need to bring that up that, hey, it wouldn't even make any sense. If you went over to Jams and said you were filing a complaint, they're going to ask, well, okay, well, what's the claims against the creditor? Likely wouldn't. You don't really have any in most cases. So that's what I would do. If the court has given a deadline of when it needs to be done by and they haven't pursued it, I would file a renewed motion to dismiss and see if they'll check it out. If the court just dismissed it and didn't do that, I wouldn't do anything. I would just hang tight and wait and see what it is that they do. So, all right. Let's see what Mr. Lowrider 3 has to say. Should I deny all the questions they asked me in the petition that I got served? This is a good question because, first of all, you've got to be accurate and honest in your response to the court. So you get the complaint or the petition, and it has a bunch of numbered paragraphs, and the court wants you to know whether you admit the allegations, whether you deny the allegations, or whether you lack sufficient information to be able to admit or deny the allegations at this point. So those are kind of your big three answers: admit, deny, or basically I don't have enough information, so I'm just going to deny it for now. You've got to be honest in it. You've got to be accurate in anything you file with the court. And particularly if you're getting sued by whether it's an original creditor or a junk debt buyer, there are certain questions. If you know that you have the card, yeah, you could admit that. If they allege that you had a Visa card, but they don't give you the last 4 digits of it or whatever, then you can say you lack sufficient information. Or like the balance that they're alleging. I hear people a lot that say, hey, this was a credit card that had a $2,500 limit and they're suing me for $3,800. If you don't know how they came up with that dollar amount, if you don't have independent knowledge, I think you're okay to either deny it or say you lack sufficient information right now until the litigation gets going on. And this also applies to junk debt buyers. They always allege in there, at least they should, that they've been assigned the debt, that they bought the debt. If you don't know that for sure, and generally the documentation they provide, particularly with the petition or the complaint, is not enough, then I would deny that or say that you lack sufficient information at this point. So the main thing is to be honest with it, but also to be accurate. And sometimes being accurate means being very accurate, meaning if you don't know for sure, have independent knowledge as to a specific fact, you can either deny it or say that you lack sufficient information on it. So, all right, let's see here. Let's see what Goshen has to say. Original creditor dismissed trial 5 days before trial without prejudice. Scale of 1 to 10, how worried should I be of them filing another one, in my opinion? So one thing is, and I don't know what jurisdiction you are in. Usually, if you're right before trial, that means that you have filed a response to it, and they're not able to dismiss without you agreeing to it. You've got to sign off on it. But if they dismiss without prejudice, which means they can refile it, the fact that they're doing that means that there was something wrong with their case. They didn't have the documents, they didn't have the witness, or maybe the witness couldn't show up at the trial because of when it was scheduled. It could be something where they found like a statute of limitations problem, where they kind of, for the first time, started digging into it and preparing for the trial. So there could be just some overall problems. There could be some procedural issues that they were running into. The main thing, they could refile it. I've seen it done. I've seen it done many times where they refile these cases, but I've also seen a lot of times where they never do again, particularly if they waited for a long time, like right up to the statute of limitations. If it gets dismissed and then they refile it, now you're that much further along in the statute of limitations, and it's going to be a problem for them. So it's always hard to tell, just because there's a million different reasons why they could have dismissed, but clearly there was something wrong. They did not want to go to trial with what they had, or there was some kind of conflict and they wouldn't be able to present their case. So yeah, that's what I'd say there. All right, let's see what Joe says. Can the amount of debt ever override the means test? So this is in reference to a Chapter 7 bankruptcy. In order to file a Chapter 7, you have to qualify based upon this thing called the means test. So we plug in like your income and your household size. I can show you. Get some of my paperwork here that I do on my consultations with to have the up-to-date number. So, for instance, in the state of Arizona right now, to qualify for a Chapter 7 case, For an individual, the max amount of income is $58,462 a year, or about $4,800 a month. And then it goes up all the way up, like I have here in my sheet. A family of 8 in Arizona can make $129,000 a year, or about $10,778, and still qualify for a Chapter 7 bankruptcy. So Joe's asking here, does the amount of debt ever override the means test? In general, the debt does not matter. Whether you have $1 or $1 million, they're going to look at really your household size and your income. However, there is a point where debt does make a difference. And that is, even if you make more than the means test will allow, if your debt is at least 51% business related, then the means test is off. If your debts are not primarily consumer debts under the bankruptcy code, then the means test doesn't apply. Now, consumer debts could mean everything from your home to your cars. So if you add all that together, and then you also have this giant business debt that's out there that's at least 51% more than the total amount of your debt, then the means test isn't going to apply. So it's also important to know with the means test that it varies from state to state as far as the income, household size, those requirements. And even if you're slightly above it, there's deductions where we can try to work that in. I've been chatting on the phone too much today. All right, let's see here. Let's see what Michael has to say. When a creditor already has a judgment against you, do you need to file anything else if they try to take assets from you? Or is there a notice of some sort? Or do they need to file something? Sorry. So if they have the judgment, I mean, the low-hanging fruit for most creditors is they do wage garnishment or bank levy. And they do need to file an application for a writ of garnishment with the court, get this court ordered that they then serve on the bank or they serve on your employer. And then, the bank will freeze the funds right when they get it, or your employer is required to start taking out money out of your next paycheck. The issue with it, at least in Arizona, like the wage garnishment thing, they'll file their application for a writ of garnishment, and then they'll serve it directly to your employer. And it's your employer who often has to give you the paperwork. And so usually you don't see any of the paperwork until the very last minute, until it's already happened. Same with the bank levy. So they do need to file it. In some jurisdictions, like here in Arizona, we could monitor cases online, and you can see when there's new entries in there. And if you see that writ of garnishment or that application for writ of garnishment, you need to either get this thing settled or look at a bankruptcy option, because things are going to be coming pretty darn quick. So, Michael, I hope that is helpful, and I hope that all the other information we talked about was helpful for you today. If anybody else has questions, feel free to put them in there. I do go back and respond to the chat later on. And if you're in Arizona and you want to talk specifically about bankruptcy or debt collection lawsuits, go ahead. My contact information is in the section below here. I'm happy to talk to you. I do a free consultation. That is only for Arizona people, unfortunately, because I can't deal with out-of-state cases. But hey, thank you everybody for checking in tonight.